A trust is a relationship that arises when a person, known as the testator or settlor, transfers the legal or equitable interest in a property, whether real or personal, to another person, known as the trustee, for the benefit of a third party, known as the beneficiary.
There
A
are
trust
several ways by which a trust can be terminated, one of which is court intervention. The court may order that the trust be terminated where it finds that the trust is illegal, it is defeasible, or it is contrary to public policy. By the provision of Section 839 of the Company and Allied Matters Act, a court may order that a trust be terminated where it finds that it is being mismanaged by the trustees or where it finds that it is in the best interest of the beneficiaries.
Another way by which a trust can be terminated is by mutual agreement. This is when the parties involved in the trust, that is the beneficiary and the trustee, mutually agree to terminate the trust. This often requires a unanimous consent between the parties or a formal writing.
According to the case of Saunders vs. Votia, the parties must be of age, must be competent, and must come to a mutual agreement, and then the terms of the trust must permit them to break the trust and then share the assets that comes from the trust.
Section 839 of the Companies and Allied Matters Act allows for the court to call for the termination of a trust if it finds out that the trust is being mismanaged or if it is in the best interest of the beneficiaries. The court may also appoint an interim manager or provide for a scheme for the administration of the trust, which may lead to termination if necessary.
A trust can be terminated by operation of law. This happens when a trust comes to an end without the express or formal act of a settlor, testator, trustee, or the court. That is, such trust ends automatically as a result of circumstances like death, bankruptcy, or disability. There are various ways of which a trust can be terminated by the operation of law, and they include 1. Fulfillment or completion of trust purpose, as in the case of the above primitive. In that case, the testator divided certain property to a trustee for the education of his grandchildren, and on fulfillment of that trust, a question was raised as to what was the return of the property. However, it was held by the court that since the trust property was for a specific purpose and that purpose has been completed, then the trust ceased to exist. 2. Expiration of trust period. 3. Destruction or loss of trust property. Once a trust property or object is destroyed, such trust is as good as done, as there is no possible way it can be completed. 4. Impossibility or illegality. For example, a trust set up for the procurement of arms for terrorists. 5. Death of beneficiaries, as in the case of boys versus boys, where a testator divided 4 houses for his daughters on the condition that the first daughter picks any house of her choice. However, before she could pick the house of her choice, she had died, and it was held by the court that that trust had been terminated.
Another means by which a trust may be terminated include the revocation by the settlor. If the trust is revocable, the settlor, the person that created the trust, may terminate the trust at any time before the purpose is being fulfilled.
In the case of Albert Taylor versus Woodbury and others, 1942, the court held that a settlor can also revoke a trust. In this case, the settlor, a young woman who had inherited a significant fortune, was persuaded by her father, who was also a solicitor, to make a settlement of her property via a trust deed. The trust deed included a clause inserted without her knowledge that if she dies intestate, her father would inherit her property, excluding her husband and her maternal family. The court, however, decided that the settlor can revoke the trust based on the reasonable ground that she was prompted under undue influence by her father to make a settlement deed of her property under a trust instrument.
Well, after listening to our classmates discussing about the termination of trust, you can all discover that trust can be terminated in several ways, ranging from fulfillment of purpose 1, expiration of terms, mutual agreement, then reflection by testator, and designation by trustee. We should always have it at the back of our mind that trust can as well be terminated through court intervention. That is in pursuant to Section 839 of Company and Allied Matters Act. A trust relating to investment can also be terminated pursuant to Investment Security Act year 2007. So it is pertinent to know that termination of trust will occur in several ways, not just one approach or one way traffic. Thank you, sir.